Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. One of the documents that was released to the public that had been under seal amongst many that were under seal during the pendency of the Idaho versus Kohberger case was a set of court minutes for what was alleged to be a sealed and closed hearing, noticed as a hearing on the defense's motion regarding alternate perpetrators. The matter of this closed and sealed hearing was noticed to the public, to counsel, on the 29th of May 2025. We see here the hearing notice giving official notice that there were two matters that were going to be entertained by Judge Hippler regarding this case of Idaho versus Kohberger on June 18th, 2025, commencing at 12:30 p.m. at the Ada County Courthouse, where all parties and counsel were required to be present. We see what the two matters were that were noticed. One was the motion to continue the trial. That was unsealed, that was open to the public. The second, however, is the motion regarding alternate perpetrators. That is the sealed and closed hearing. So we see just two matters that were scheduled on May 29th, 2025 in the case before the presiding jurist, Judge Hippler. However, once the minutes were published, the minutes seemed to, in my opinion, tell another story entirely. That there were actually two hearings that were held behind closed doors, sealed and closed to the public, one of which there was no notice of. And that has to do with what the court referred to here at 1:25:33 p.m. to be, quote unquote, some trial miscellaneous stuff, end of quote. However, if we look here at the notice of hearing, there is nothing here providing official notice to the public and to both sides that Judge Hippler intended to also address trial-related materials here. And it was a significant portion of this closed and sealed hearing. We know that by looking at the minutes here. The description of the minutes for June 18th, 2025 states that the sealed section starts here at 1:25:05 p.m. and this is noticed as 1:25:06 p.m. Case number, style of the case, topic, motion regarding alternate perpetrators, sealed. Nothing about pretrial conference, nothing about discussing the trial, nothing about a case management conference where anything else besides this noticed matter would be addressed. And yet we see at 1:25:33 p.m., the court then giving notice to the people that were behind closed doors that once the alternative perpetrator oral argument would end, they were going to go into matters regarding the trial. So then at 1:26:03, they start with alternate perpetrator, oral argument, counsel for the defense, Ms. Massoff, begins. The alternate perpetrator section of the hearing went on for several pages. A lot of it is redacted. We're going to come back and address it at another time. But what I wanted to call your attention to is that the portion where the hearing on alternate perpetrator ends appears to begin somewhere around 2:07:44 p.m. We see here that the judge at 2:07:44 p.m. says, I wanted to talk to you about the summons that went out to the jurors. As these things go, the TCA has received a call from a reporter that says, quote, hey, I got this summons to show up on the 21st. Is this for this case? End of quote. Of course, the TCA didn't tell them anything. Begs the question, seems to me that we can save everybody a lot of headaches. And I know that in the Daybell case, I think that something similar happened. The reporter reported on their experiences as a juror before they even had been excused as a potential juror. My suggestion is that if I see red flags like that, to let you know and see if you both would agree to taking them off the list. Save ourselves headaches down the line. That's not somebody who should be on our jury. I wanted to bring this to your attention and see if there is any concern with the one that I am aware of, which is, and then he gives the person's name, and having her taken off the jury list. So in my opinion, if I can interject a thought, a comment, pure speculation here, we see the judge now seemingly, in my opinion, taking the role of the parties in determining whether a juror should be struck or not struck in this behind closed doors hearing, unnoticed to the public. What is it about this Ms. Romero that Judge Hippler wants the parties to strike even before voir dire, to which they both stated they had no concerns, no objections, as we see here at the 209:23 and 209:27 mark. And then in the next page, they go into addressing if a still photographer should be permitted to be in the courtroom for certain proceedings. Does anyone have a problem with that? We see Mr. Thompson here saying, I think the media should consider themselves fortunate. And then the judge responds, they will not be permitted to photograph victims or jurors. And then Ms. Taylor jumping in with, while we have witnesses who would not be classified as victims, they're vulnerable. So they're having these discussions, and they continue to have these discussions over the next several minutes. This went on for almost a half hour. So this was approximately just under half of this hearing was dedicated to something that had nothing to do with the matter that was noticed in a case where there has been so much that has been accomplished under seal outside of the public realm. One only needs to look at the case summary page and look at the document after document after document that you see that's been under seal in this case, and the hearing after hearing after hearing that was closed and sealed. I am looking forward, in my opinion that I give under the First Amendment, to see more of these sealed hearing minutes to see exactly what happened behind closed doors. There will probably be heavy redactions, possibly like this one, but just to note and see if things went on into other areas that were not noticed in this case. If you have any comments, any thoughts, any opinions, please leave them here. Until next time, this is Kathy. Thank you for joining us here today.